The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much, and welcome to the Massachusetts Appeals Court session for March 9th, 2023. This is actually just a special sitting where we're going to be hearing one case, which is Gloria Brown versus Vero Healthcare, 2021 P949. So this is we're having this hearing at Ms. Brown's request on Zoom, and we're doing it. It's simultaneously being shown on our YouTube channel, and it will be available on the archives later, so you can view it at a later time. Aside from that, we follow our normal procedures, which is each side gets 15 minutes and there's no rebuttal. We've read your briefs. We're familiar with your arguments, so you can get right into it without many preliminaries. As I said, so Ms. Brown, you'll go first. You have 15 minutes, and feel free to use all your time, but you don't have to if you don't want to. There's no penalty for finishing early. You cannot. There will be a clock shown that you will not be able to see, obviously, and I'll give you a few. I'll let you know when it's maybe 3 minutes left and 1 minute left. So
yes, sir.
Okay, so the floor is yours.
Good afternoon. My name is Gloria Brown. I apologize for my speech. I filed a civil complaint in Suffolk Superior Court in 2020. I didn't learn the circumstances surrounding my late husband's death until February of 2017, when I was provided a portion of my late husband's medical records from the nursing rehab center. The days leading up to and including my husband's death, my husband died at age 77 years old while residing there. I filed and served a negligence complaint in 2020 within 3 years of my discovery of the circumstances surrounding my late husband's passing in 2017. Despite the defendant's argument that I did not file this civil complaint, I've asked VA this appeal that this matter is remanded back to the lower court. I'm asking that findings of fact in the trial court, as there is no evidence in the record to support the judge's findings, in order and should be rejected by the full panel. Findings of fact that I did not file an opposition are not supported by the court record. I ask that the full panel reject the trial court finding that I did not file an opposition to Vero's motion to dismiss, which I did. I offer that the record is clear that on 12/30/2020, Judge Rakucci said, see appellant's record, volume 1, page 19, is clear that the appellant's motion to reconsider relief from judgment was allowed. The docket reflects that on 12/22/20, the motion was granted. Excuse me,
Excuse me, Ms. Brown, I'm going to interrupt you because I have a few questions, and I'm sure the rest of the judges also have some questions.
Yeah.
And for me, the main thing that concerns me in this appeal is the timing, and I just want to ask some questions about that. This is Justice Massing, by the way. So I understand that in your first complaint, you said that your husband received substandard medical care between 12/31/16 and January 7, 2017. And there are also papers that say that you just said now that you didn't really understand the circumstances until you received some documents a month later. What was in the documents that you learned that you didn't know before?
Well, first off, the first set of documents that the rehab, the nursing home gave me, they said that it wasn't the full record. It wasn't everything. And then that it was about my husband, his breathing and being unresponsive, but it stopped there. I never got a full, they're full records. The records that I got showed they had been changed, white out on them, and he was unattended for a long period of time on the date of his death.
So did the documents show that he was unattended for a long period of time on the date of his death?
Yes, yes. In fact, it was said that he was doing agonal breathing, and the nurse said she would come back later and check on him. And at some point, they said he passed. But the medical records, I noticed that they had been changed white out a few times, but the first set that I got, partial set, said that he had agonal breathing, and they returned, it looked like an hour or so later, that he was deceased.
Ms. Brown, this is Justice Sachs. I wanted to just interject here with a question. Did you ever file those records or describe the contents of those records to the judge? The part about him not having been attended for a long period on the date of his death?
No, I've never gotten that far in the case. No one asked me for them. I still have them, but they were whited out, changed, and it does say, in fact, I believe they said he had agonal breathing when the paramedics, no, he was already deceased when the paramedics came.
So you didn't, I know you didn't attach them to the amended complaint that you say that you filed. At least I didn't see them attached to that in the record. And I looked at the hearing, the hearing before Judge Buckley, was it the last judge?
Yes.
And I didn't see that that allegation or that fact mentioned about your husband having been left unattended. So I just want to be sure I understand whether there was any point at which you presented this fact as to why you didn't learn until February of 2017 about that some negligence might have led to your husband's death or suffering.
Because that is correct. During those hearings, that's why Buckley said that I should amend the complaint, I believe. I remember, I'm trying to remember, I'm sorry, I'm struggling a little bit, but they were never asked for in court and never, I'm trying to remember exactly what she said. No, well, I know we never discussed it because Judge Buckley said she had no amended complaint.
Yeah, I remember seeing that. Okay, well, that
Right.
answers my question. If you didn't bring it to her attention, that tells me what I wanted to know about that issue.
And can I ask one more follow-up on that, which is, so before you received those documents and you learned about him being unattended and the agonal breathing, what did you think had happened? And I apologize if this, I know this is, obviously a difficult thing for you, and I apologize for that. But so, but before you got those documents, what was your understanding of what had happened?
Okay, he was 77. No one told me what happened, just that he had passed away. They said they were with him when he passed, but I believe that was just on the phone. Because he had prostate cancer and was 77, 78, I thought that was, he just had his advanced age and that he had just naturally passed away. But after I got the partial records from the company, that's where they explained they saw him with agonal breathing and left him there for some period of time. Said the person said he was having agonal breathing. I decided to come back later. That's what they said on the. That's what the nurses said, and they put it in the record. I asked for the records, the complete records, and I still have not gotten them. They did not give them to me. And what they did give me had all kind of whiteout spots on it, so I didn't know until February of 2017. I was finally getting to the bottom of it.
Could I just jump in here and ask a question, Ms. Brown? This is Justice Walsh.
Yes, ma'am.
Do you ever remember filing an amended complaint?
I did. I filed it was the court said I had to, or I could file it. It was document number 32, I believe, 32 or 33, 32. That I did file it. It was my 9A package, and in that was everything. It was the defendant's opposition. The complete package was there.
Okay.
Yeah, the stamped copies of it too, which I have, when they were received by the court, hand delivered.
Are those stamped copies anywhere in the record appendix?
But yes, they are there.
Okay. I see that on page, in the record appendix volume 5, on page 3, there's a cover letter to the court that lists a number of documents being filed pursuant to Rule 9A. And I see that that has a stamp from the court saying it was received on April 20th of 2021.
Yes.
It says plaintiff's motion for leave to file an amended complaint with proposed amended complaint annexed.
Yes, sir.
So is that the document you're referring to?
That is correct. It was a 9A package. I believe everything was in there. Was yes.
Yeah. Okay.
Excuse me. The only thing that got me confused is that Judge Buckley didn't consider my amended claim.
I'm sorry, actually, Ms. Brown, there's 4 minutes left. I'm gonna ask you to stop for just a second because we somehow lost Justice Walsh. You still have 4 minutes left, but let's hold on for a second, see if Justice Walsh comes back. This is very unusual. She maybe is having internet problems or something like that. So just to bear with us for just a second, please. And we'll remember there's 4 minutes that this happened with 4 minutes.
I put a pause on the recording.
Okay.
So we'll go back. Yeah,
The clock's still counting down, but
oh, I know, it's just.
yeah.
Should I continue with?
No, just wait, please. Well, just give us a moment. Hopefully Justice Walsh can join us again. I'll let you know when she's back. Let's give it a minute.
Thank you.
All right, here she comes. Hold on a second, please.
Justice Walsh, can you hear us?
I can hear you. Was it
Okay.
just we lost the internet for a moment?
Yeah, so we that happened with 4 minutes left in Ms. Brown's arguments. We stopped and waited for you to come back. But so
Thank you.
now we can resume. So 4 more minutes, Ms. Brown. Sorry about that interruption, and thank you for your patience. And thank you, Attorney Gray, for your patience too.
Yes, sir. Well, I'm asking that findings of fact in the trial court, is there no evidence in the record to support the judge's findings in order and should be rejected by this full panel? Findings of fact that I did not file an opposition, which we just went over, are not supported by the court record. I ask that the full panel reject the trial court finding that I did not file an opposition to Vero's motion to dismiss, and I offered that the record is clear that on 12/30/2020, Judge Ricardo said see appellant's record appendix volume 1, page 19, is clear that the appellant's motion for reconsideration, relief from judgment, was allowed. The docket reflects that on 12/22/20, the motion was granted. Despite the claims of the appellee, the judgment was vacated. Judge Rick's order detailed that the appellant must complete certain actions by a certain date. The docket reflects that the appellant performed all actions properly and timely, as noted on the docket. The judge's order required the appellant to serve an opposition to Vero's motion to dismiss by January 15th, 2021, which I did pursuant to Superior Court Rule 9A. And you can see the record appendix, volume 3, page 25-49, docketed as paper number 23, which indicates that the appellant's opposition was served on 1/15/2021. The trial court improperly dismissed the appellant's civil complaint. Trial Court Justice Buckley's order and decision on the defendant's motion to dismiss, dated May 20th, 2021, is based on erroneous findings of fact which are not supported by the record of the appellant through this appeal, and seeks that the full panel of the Massachusetts Appeals Court reject all findings of fact of the trial court which are not supported by the trial court docket. And first, the appellant asserts that Justice Buckley's order is based on the first complaint filed by the applicant instead of the amended complaint that the appellant received by Suffolk Superior Court on April 20th, 21. Justice Buckley erroneously made a finding of fact that the appellant had not filed an amended complaint. The transcript from the actual hearing reflects that the appellant informed the justice that she had in fact filed the amended complaint. The appellant further asserts that Judge Locke's prior order that the appellant was required to file a motion for leave to file an amended complaint was also erroneous, because by the time of the hearing before Judge Locke on February 23rd, 2021, it was failed to adhere to the construct of Mass Rules of Civil Procedure Rule 15, which dictated that the appellant did not need to file a motion for leave to file an amended complaint, as the defendant had never filed a responsive pleading, and as no judgment had entered against the plaintiff, as Judge Rick's order docketed on 12/22/20 dissolved his previous order granting judgment to the defendant and allowing the defendant's motion to dismiss. Following the grant of my 59 motion, at the point of litigation was again live, and the judgment was then dissolved.
I'm sorry, Ms. Brown, I'm gonna interrupt you now. The time you've now got to the end of your time. So if you can sum up briefly, I'll give you another minute or so. But just I think we're gonna have to hold it at that.
Oh, should I go ahead?
Just if you could just summarize the what you'd like us to do.
Okay. The trial court overlooked and disregarded my filing supported by the court record. The overlooked or erroneous findings that the appellant did not file a written opposition prejudiced the appellant and deprived her of the arguments and objections briefed, served. The appellant requests that per this appeal, that the full panel to reject the erroneous findings of fact that contradict the court record, and the appellant agrees. The appellant argues that it would be improper to permit the order on the motion to dismiss to stand without allowing the trial court to fully consider the applicant's opposition that was actually before the trial court, and therefore the grant of the motion to dismiss was an abuse of discretion based on an erroneous filing of fact.
Okay, I think let me see if anybody else has any more questions. Seeing none, okay, thank you for your argument. Stay on the line. And so this is Attorney Gillis's turn. And so, ask you to just stay on and listen, but not to speak, okay?
Very well.
Thank you. Attorney Gillis for Vero Healthcare.
Good afternoon, Your Honors. May it please the court. Under any conception of the plaintiff's case, the dismissal should be affirmed. Any applicable statute of limitations is 3 years, and the original complaint was filed more than 3 years after the decedent's death. I'd like to begin by addressing the motion to strike. The only complaint that's properly before this court is the original complaint. The proposed first amended complaint that is at Record Appendix Volume 5, pages 3 to 10 should be stricken because it was not in the trial court record. We know that the proposed amended complaint was not in the Superior Court record because for a number of reasons. It's not referenced.
What if we assumed, Mr. Gillis, that it was in the record? Why don't you, we understand your argument that it's not, but if we weren't to be convinced by that argument, why don't you address whether that complaint is sufficient to address the various defects that had previously been identified?
Sure. Even if the first amended complaint is part of the record, the result would be the same. The statute of limitations under the wrongful death statute, the medical malpractice statute, and general negligence are all 3 years. And the complaint, both complaints allege that the decedent George Brown received substandard medical care between December 31st and January 7th, and that aided in his death on January 7th, 2017. And the complaint was filed on February 12th, 2020. Now, the discovery rule, which Ms. Brown must rely on, only applies when negligence and harm are inherently unknowable, as in the case of an undiagnosed asymptomatic disease. That's the International Mobiles case cited in our brief. And there's no allegation in the complaint or in the record below that the negligence or harm here was inherently unknowable. The standard does not require that the plaintiff hold sufficient evidence to prove legal harm. It's just sufficient notice that medical care may have caused the injury. And here, Ms. Brown alleges that Mr. Brown passed away while in the care of the defendant entity. And that is sufficient to put a reasonable person on notice of a potential claim. And
Why
for
is
the
that?
statutory, because, Your Honor,
Is it res ipsa loquitur? I mean, you have to have, well, go ahead.
Your Honor, I believe because he's in the care of someone else and he passes away, that gives knowledge of harm and a potential cause of the harm, which would be different if it was just any person who's not in the care of a facility or being treated for a medical condition. And I think that if that is not the rule, that in general, someone in the care of a healthcare provider that passes away, that then puts everyone on notice of a potential claim, you run into a circumstance where effectively a personal representative would hold the keys to the accrual of the statute of limitations period. And every statute of limitations period is potentially then going to be delayed by their choice of when and whether they solicit medical records. And I would say here that Ms. Brown, and although this isn't in the record, either Ms. Brown's argument that she didn't learn until February of 2017 that what had happened, the very fact that she was looking at the medical records would seem to indicate that she was on notice at that point of a potential claim. The legislature provides 3 years to investigate a potential claim. Ms. Brown's argument that on page 25 of her brief that it was not clear to what occurred on January 7th does not toll the statute. Clarity is not the standard. If I could address just a couple of the other points that Ms. Brown raised during her argument. One is about the status of the judgment below. It's not clear on the Superior Court record does not say that the Superior Court judgment that was initially entered was vacated. Relief from judgment was granted. However, the relief provided was to allow Ms. Brown to oppose the motion to dismiss. And as a practical matter, Judge Buckley later also granted, I guess, a second time the motion to dismiss and referred in that order back to the judgment that was previously entered. So that would not be a basis for reversal. And if it was, it would only be to re-enter a judgment. And for reasons of judicial economy, I think the record is complete here before the appeals court. And also, as to Ms. Brown's argument about her ability to amend the complaint as a matter of course, rather than required to file a motion as Judge Locke permitted, two arguments to that. She never attempted to file an amended complaint without a motion, so that argument is waived. And second, the amendment under Rule 15, the amendment must be made prior to the entry of an order of dismissal, and an order of dismissal had previously entered by Judge Ricciuti. So she was required at that point to file a motion to amend with a proposed amended complaint under Judge Locke's order. And going back to the motion to strike briefly, we know, at least based on the record, that the amended complaint wasn't filed. It's not referenced in the docket sheet. Judge Buckley stated during the hearing that none was filed, but she would check the record again. And Ms. Brown acknowledged even in the hearing that seemingly that she had checked with the docket room prior to the hearing, and that there was some question about whether she had some question about whether it was filed. But most importantly, Judge Buckley's decision expressly states that no amended complaint was filed. It's the appellant's burden on appeal to establish the record. Essentially, Ms. Brown's asking for the court to assume the veracity of her representations, and that the Superior Court lost a document, but the court does not need to make any such assumptions. It is the appellant's burden to establish the record. So the motion to dismiss, the motion to strike the proposed amended complaint as included in the record appendix should be granted. But as I said, whether the court considers the case under the original complaint or the first amended complaint, the result is the same under the statute of limitations.
As far as I can tell, I mean, the only thing that really changes in the amended complaint is she establishes there that she's the personal representative of the estate, which was maybe not in the first complaint. Is that really the only main difference?
That is, Your Honor. So if the court did consider the complaint as the proposed amended complaint as filed, that basis for the decision that she lacks standing for failure to establish her status as personal representative, that would not be available. But the statute of limitations argument is the same.
Can I ask you about your personal jurisdiction argument? I mean, this facility is clearly in Massachusetts, right?
There was a facility in Massachusetts. The party that is named in the complaint is not a Massachusetts entity. It's not the entity that operated that facility at that time.
Isn't this just a misnomer issue rather than a personal jurisdiction issue at most?
It may be, Your Honor. However, there's no, Ms. Brown has cited no law that would effectively reverse the decision below based on a misnomer. Misnomer was not the basis of the Superior Court's decision. And she was given the opportunity by the Superior Court to name the proper entity in a proposed amended complaint, and did not do so.
She had some difficulty doing so because whichever entity was actually responding, and it's very difficult for me to tell by looking at the record who was purporting to respond, was being extremely cagey about who they were. Which doesn't reflect well, candidly, to express my personal view of the matter. Made it very difficult for her to name the proper party, which she was trying to do.
I appreciate that, Your Honor. I was not counsel at that point in time, but I don't believe that there is a requirement for counsel for one entity to give further information about another entity. I do believe that the entities are related in some way, but I'm not sure of the exact corporate structure. We were retained to represent the named entity in the complaint, and filed a motion to dismiss on that basis.
Let me just go back, if I could, to the amended complaint. Again, understanding your position that it was never filed, but the one that's in the record appendix 5 at page 5, includes some additional allegations about not just being a personal representative, but also about the circumstances of Mr. Brown's death. And paragraph 7 says, in violation of the duty of care owed to the plaintiff's decedent, the defendant's agents were negligent by failing to observe, monitor, and provide care, and by failing to respond appropriately to the rapid decrease of blood pressure, pulse, and oxygen rates of the decedent, George Brown, resulting in pain and suffering on January 7th, 2017. Does that affect your view on whether the that information gleaned from the medical records, I suppose, it had a role in tolling the limitations period or establishing the discovery rule?
Your Honor, I don't believe that has an effect on the statute of limitations or tolling the discovery rule, because while that is additional detailed information, it's not information that was inherently unknowable. For example, the cases typically refer to an undiagnosed asymptomatic disease, but that information was not inherently unknowable at the time. Those were things that happened.
Can I interrupt for a moment? In part, it was unknowable for a while until she received, it looks like much later, a redacted portion of the medical reports, right? I mean, so how would she have known that there may be some medical negligence? Because nobody was saying that there was.
So
because she looked for at the autopsy or the death certificate?
So I think there's a couple aspects to that, Your Honor. First is that the standard doesn't require her to have all of the facts known at that time. Those facts that she alleges in the proposed amended complaint, she could have alleged that there was substandard care at any point. And moreover, Your Honor, the statute of limitations is designed to provide some level of finality, and it permits a 3-year waiting period for her to gather the information necessary, which she apparently did. I'm not aware, and there's nothing in the record about what medical records were provided to Ms. Brown. However, the very fact that she was seeking medical records at the time shows that there was notice of a potential claim, and the statute provides 3 years to investigate and file the claim, but it was not filed. And I think that, as I mentioned earlier, if the rule to be adopted is that in any wrongful death case, the statute doesn't start running until the personal representative can obtain medical records and complete a full evaluation of potential claims, that would effectively extend the statute of limitations and create an unworkable rule where the courts would have to decide whether how swiftly a personal representative acted, and has the potential to extend these claims many years down the road, particularly for assisted living and rehabilitation facilities, which obviously have a much older population. Unless there are any further questions, for these reasons and those discussed in our brief, I'd ask that the court affirm the Superior Court's denial of the motion to amend and dismissal of the case.
Seeing none, Thank you, Attorney Gillis, and thank you, Ms. Brown. We are, and this, you actually, you could hear you perfectly well, Ms. Brown. I want you to know that you did a nice job of presenting your case, as did you, Mr. Gillis, and we'll submit the case and issue a decision as soon as we can.
Thank you, Your Honor.
All right.